out of Massachusetts in the case against Karen Read. The Judge Beverly Kearney, has granted, in part, the Commonwealth's motion to receive communication between Karen Read and Aiden Kearney. We know that, AKA Turtleboy. There they are, talking in the courtroom this week. And this is big. This is a big win for the state. The motion includes communication between Turtleboy and any witnesses involved in the murder of John O'Keefe. It also grants the Commonwealth access to pictures and videos depicting any evidence of intimidation, because this is a big part of their case, that they believe that Turtleboy was intimidating witnesses. And we heard that come out in the first Karen Read trial. To what degree it comes out this time, it still remains to be seen. She, of course, is accused of running over her boyfriend, Boston police officer John O'Keefe, back in 2022. Another bombshell of a motion has been filed by the Commonwealth, and this is interesting. The Commonwealth now wants text messages between Karen Read and David Yannetti. David Yannetti's her lawyer. That's her first lawyer, the Boston-based attorney. They want it from 1/29 to 2/2/2022, so January 29th through February 2nd. Why? Because they argue that she waived attorney-client privileges for those dates because she talked about a conversation that she had with David Yannetti in one of the documentaries that she's done. If you've watched this Out in the Snow, the Body in the Snow documentary on Discovery ID, it's fascinating. They have huge access. Well, she talks about, I had a discussion with Yannetti. They're arguing because she talked publicly that they should get text messages between her and her attorney. Matt Johnson's going to be joining us with much more next hour, but let's bring in Jacqueline Goodman. Where do we start? Let's start with Turtleboy. The Commonwealth really wants to make sure that this jury in Karen Read 2 has the same as jury in 1, and that is that they get a sense of this witness intimidation. They want these two cases to be brought together. Right now, Turtleboy's got his own track going. What's your take on Judge Kearney allowing at least the weaponry, the info to be shared with them? Whether or not they'll be able to present it or not, we'll have to wait and see at trial. But one would argue a big win for the Commonwealth to receive that information concerning Karen Read and Turtleboy texts.
Sure, it's a huge win for the prosecution, and it's the first of two hurdles that they've got to cover. So initially, it's the disclosure that the prosecution wants, and then they go through that information. They still have another hurdle at trial as to its admission in front of that jury. But boy, that's quite a win for the prosecution. Obviously, that's a pretty devastating blow to the defense.
Because the sense that if you're a juror and you think these innocent people that are just witnesses are being intimidated, it adds a color to it. And the defense was able to sort of do that reversal-wise with the investigators and Trooper Proctor, et cetera, give you a bad feeling. If they can replicate that, it'll bode well for them. What's your take on this other motion just filed today? They want communications between her and David Yannetti.
That really strikes fear in the hearts of every criminal defense lawyer, I'll tell you, and every lawyer. The attorney-client privilege is so sacrosanct that it is really difficult to pierce that veil, if you will. But what happens is that someone goes on television like this, talks and talks in this documentary, a very, very bad idea if charges are pending or can be brought. And then they disclose what is part of this otherwise protected communication. And when someone does that, that's what we call waiver. They waive the privilege. So even though the law really does protect that attorney-client privilege very carefully, so that we want clients to be able to speak very freely with them, the client can waive that privilege. They're privileged to waive. And when they these communications to third parties, well, then it's sort of what's, if you can go on and say, this is the privileged communication and therefore it helps me, then the prosecution can now know what is the rest of that story and does it really help you? So it's a way for the prosecution or for the other party in any event to speak back to those claims and to be able to parse those claims and challenge the credibility of the spin that the witness is giving to those communications. So it can be very devastating. You can imagine the treasure trove of information that is going to be in attorney-client privileged communications with someone who is facing these types.
Oh, absolutely. And especially in this case of all cases, just the insanity that revolves around this case. They're only looking for a couple days, it's January 29th through February 22nd, because that's what they say that she opened the door in. But can you open a door? We see it all the time in a case here on Court TV where someone does it on the witness stand or someone does it in a courtroom. They open the door to a subject and boom, now the other side has the ability to walk right through it. Can you really open the door to attorney-client privilege out there on television or in public? Does that argument make sense to you?
It does. I see what you're saying. The difference between saying these things from the stand and saying them out in the real world. But the answer is yes. The privilege is something that is very closely protected, and so as you've seen, and even in the request, the court and the people are asking for something that is very short and distinct, a very clear parameter to what communications they're asking for, because they don't broad with the request, and the court is definitely not going to want to be overly broad, allow just complete openness about their communications. But yes, making those statements on the documentary allows it's the waiver, and that waiver can take place inside the courtroom and outside the courtroom. So the remedy might be slightly different given the surrounding circumstances, but the waiver is the waiver wherever that occurs, and the prosecution now can speak back to this discovery because it's literally just been waived. Right. Narrowly drawing that remedy for the prosecution is the way the court is going to balance that difference.
Yeah, okay, well, we'll see what Judge Kearney says about that one, but at least temporarily, to your point, phase one of their attempt to bring in Turtleboy has been accomplished from the Commonwealth's standpoint with her ruling there. We'll see how she rolls on the Unetti texts. Karen Reed, never ends. And again, we'll have Matt Johnson updating us with all of these motions later.